Hi, my name is Rita. I'm a staff lawyer at IAVGO Community Legal Clinic and one of the supervisors of our student legal clinic, Advocates for Injured Workers. Just before we begin today, our presentation, including the PowerPoint, is legal information, not legal advice. And the PowerPoint slides are intended to be used in conjunction with this presentation and not as a standalone document. Every case is dependent on the facts, and you should consult a lawyer if you're looking for case-specific advice or relating to issues not covered in our presentation today.
Okay, thank you, Rita. My name is Jennifer Fehr. I'm a supervising lawyer for Downtown Legal Services, the legal clinic at the University of Toronto Faculty of Law. And what you have before you is our agenda for today. So we're going to start off with an overview of employment law. We're going to move into the specific COVID-19 impact on employment law. And then we have a few questions that are relevant for the recovery. Specifically, can my employer require me to get a vaccine? And some questions around working from home. And then there will be a question and answer period. There's so much to say, and there's so much more to say than our 35 minutes will allow. So if you have any questions about the topics that are not otherwise addressed, you can save them for the question and answer period. So moving on to the overview of employment law. So here's a list of a few employer obligations to assist us in understanding where we're going to go from here. So the first piece is the safe workplace, and employers have an obligation to provide a safe workplace, and this comes from the Occupational Health and Safety Act, which is a piece of remedial legislation here in Ontario designed to ensure a safe workplace. Employers also have an obligation to provide a workplace free from discrimination. This comes from Section 5 of the Ontario Human Rights Code, which sets out 16 prohibited grounds of discrimination, and those include race, gender, as well as disability and creed. It's important to note the Ontario Human Rights Commission has actually named COVID-19 as a disability under the Human Rights Code. So that would mean that you can't discriminate against somebody for having had COVID-19 or being perceived to have COVID-19. We'll talk about that a little bit more later. Another obligation of the employer is to provide notice of termination, and that's both at statutory and at common law. So employers in Ontario have a right to terminate an employee for any reason, as long as it isn't a bad reason, so long as they provide the employee with notice of that termination. So notice is typically measured in time. For instance, under the Employment Standards Act, an employee who has worked for an employer for more than 1 year, but less than 3 years, is entitled to 2 weeks of notice. Now, instead of providing time, the employer can provide pay in lieu of notice. So rather than expecting the person to come in for the next 2 weeks, that you can pay them the value of the 2 weeks of pay. Now, it's important to know that the Employment Standards Act sets out minimum notice requirements, and those are based on length of service. Workers in Ontario are also entitled to notice at common law. So this is based on judge-made law, and these notice periods tend to be longer and take into account a person's age, their length of service, the nature of their work, and the character of their employment. Now, when I say that they tend to be longer, the maximum notice period you can get under the Employment Standards Act is 32 weeks. The maximum that you can get at common law is between 24 and 26 months. So it's quite a significant difference. It's also worthwhile to know that workers are also entitled to notice where they quit their employment because the employer has unilaterally and significantly altered the terms of employment such that they can be said to have been constructively dismissed. Now, this comes up a lot where someone's hours have been drastically reduced. So you can see how this might be an issue for in the pandemic. Employers are obligated to follow employment standards. This is things like minimum wage, notice of termination, hours of work, breaks. The Employment Standards Act also sets out job protected leaves, which employees are entitled to take if they qualify. Employers are obligated to contribute to statutory insurance schemes. That includes employment insurance and workplace safety insurance benefits, and we'll talk more about that later. And finally, employers are also required to report workplace injuries to WSIB, which will also be addressed later in the presentation. Moving on to the next slide. before I get started, I want to sort of outline a little bit of the sort of three categories of workers that have been impacted by the pandemic. The first category are primarily low-wage workers whose work has been eliminated by virtue of the pandemic. So these are people who are working in retail, who are working in restaurants, who are no longer able to go to work because of the shutdowns and the business slowdowns. Group number two are essential workers who are continuing to go to work and physically required to go to a work location under increasingly dangerous and less healthy circumstances. And then the last group are mostly professionals, high income people whose work has managed to continue, but they're now working from home. So the different things that we're going to talk about are going to speak to those different groups of workers. And this first one, changes to notice and termination in the pandemic, primarily speaks to those workers who found themselves without work. So the government of Ontario introduced a new leave, which is the infectious disease emergency leave, which I'm going to refer to as IDEL, and it's set out in Section 50 of the Employment Standards Act. So this is a job protected leave for workers who cannot work for reasons that are related to COVID-19. So this includes businesses are closed, there's school closure, you're infected with COVID-19. There's no limit of the number of days of this leave, so long as you continue to qualify. So for example, if you qualified for IDEL because of a school closure and you need to take care of your children, once the school is reopened, you would cease to be eligible for that leave. But if the business that you work for is closed and has remained closed for the life of the pandemic, you can remain entitled to the leave. In addition to IDEL, the government introduced Regulation 22820 in May of 2020. So this sets out that for the COVID period, where an employer reduces hours and or pay for reasons that are related to COVID-19, the worker is deemed to be on IDEL and not constructively dismissed pursuant to Section 56(1)(b) of the Employment Standards Act. So what this means is workers who might otherwise be able to say, wait a second, you just reduced my hours, that's a unilateral and significant change, I'd like to be treated as though I was dismissed and get my notice. They can't do that according to the ESA. Now, this has created a really interesting issue for employment lawyers because constructive dismissal exists both under the Employment Standards Act, but also at common law. So there's been a question on whether or not this restriction in the ESA also applies to an employee's right to argue constructive dismissal at common law. And kind of the center of this debate is Section 8 of the Employment Standards Act, which sets out that subject to Section 97, no civil remedy of an employee against his or her employer is affected by this act. Now, there's been two cases that have considered Regulation 22820. The first was Catino versus Ocular Health Center Limited. And in that case, the judge relied on Section 8 of the ESA to conclude that Regulation 228 does not affect a common law right to constructive dismissal. Now, shortly after that decision was released, Regulation 228 was considered again in Taylor versus Hanley Hospital, which held that Regulation 22820 does displace the common law and that the Section 8 only speaks to the ESA not having exclusive jurisdiction over employment matters. So this is a situation that for employment lawyers is creating a lot of confusion and is calling out for intervention by the Court of Appeals. So hopefully we'll get some guidance shortly on this. And the last point on this slide is the pandemic impact on notice. So for a number of industries, the pandemic has slowed down and created fewer jobs in that industry. Now, other industries are actually flourishing under the pandemic. So judges have said, if you want to argue that you are entitled to a longer notice period because there is less similar employment available, you're going to need to show evidence that in your industry, that is in fact the case. So something to keep in mind going forward. The next slide is changes to workers' income support. So this also primarily impacts that first group of workers who have found themselves without work. What is it that they're going to do for income support? And also somewhat into the second group of workers who are continuing to attend work, but may find themselves sick for a prolonged period of time and they need to access these benefits. So at the start of the pandemic, EI was seen as the main vehicle for compensating workers who were sick or would who otherwise be unable to work. Now, they quickly realized that relying on EI was not going to work for a huge swath of workers who don't work for an hourly wage, who are not considered employees, but maybe work on the basis of work completed or what we would call like the gig economy. So we're talking photographers, writers, translators, taxi drivers, some hairdressers and consultants, a lot of other folks. So for folks who don't pay into EI, there was no system in place for them. So this is a problem that workers' advocates have been highlighting for the government for a number of years. So to their credit, recognizing that a lot of people were not going to be able to access EI, the federal government created the Canada Emergency Response Benefit, which then later became the Canada Recovery Benefit. Now, this is for workers who do not qualify for EI. And in order to qualify for this, you needed to demonstrate that you experienced a 50% reduction in pay, that you earned $5,000 in the last 12 months. And in those circumstances, you would be entitled to $1,000 every 2 weeks. And there were other benefits through the CRB, which was Canada Recovery for Sickness. So if you were unable to work because you were sick, or if you were Canada Caregiver Benefit, if you were unable to work because you were caring for somebody else. And these mirror similar benefits available under EI. Now, this actually had a positive impact on EI because the $1,000 that you would be entitled to under CRB or CRB was more than some workers would be entitled to under EI. So it actually increased the floor for people receiving EI. And now for EI, the minimum that you are going to be entitled to is $500 a week. EI eligibility was also reduced in terms of the hours that you needed to qualify. And it went from being the previous minimum was 420, and now it's actually 120. So a significant reduction. So the question moving forward is, now that the federal government has been forced to grapple with this huge percentage of workers who have been left out of EI, will they fix that on a go-forward basis to ensure that in future circumstances, these group of workers will not be left behind? And now I'm going to turn it over to Rita, who's going to talk about COVID-19 claims and WSIB. Rita, you're muted.
Okay, sorry about that. Just before I begin, I want to give you a brief background on WSIB. So it's a no-fault insurance scheme that provides benefits such as lost earnings and health care to workers who are injured or ill as a result of their work. And this is funded by premiums that employers pay into the WSIB. The claims process begins when either a Form 6, a Form 7, or a Form 8 is filed. The worker's form, which is Form 6, is used to report the injury by the worker, and the Form 7 is for the employer to report the injury, and Form 8 is for your health professional. Any of these forms can start the claim process, but regardless of whether or not the other forms have been submitted, you should always submit the Form 6. And any witness information, photo proof, or medical documentation should be submitted as well. But if you don't have all of that information immediately, it's okay. You should still go ahead, file the Form 6. If you think you've experienced a workplace injury or illness, and then additional information can be sent to the WSIB after the fact. So with respect to COVID-19, workers are entitled to WSIB benefits for COVID-19 arising in and out of the course of employment. So a decision maker will consider the following factors when determining whether a worker has entitlement. The first is, did the worker's employment create a risk of contracting the disease to which the public at large is not normally exposed? And second, has the COVID-19 condition been confirmed? If these questions are answered in the affirmative, at least in theory, a worker should be granted entitlement. Claims where the answers to these questions cannot be confirmed should not be outright denied. They should still be reviewed on their merits. So it's still possible that they will be denied, and then you'll have to go through an appeal process. So when looking to whether a worker's employment creates a risk of contracting COVID-19 beyond what the public at large is exposed to, the WSIB looks at several different factors. So first, has the source of infection within the workplace been identified? So for instance, if you have a colleague with a known case that you work closely with, that could be a potential source. Second, does the nature and location of employment activities place the worker at greater risk for exposure to infected persons or infectious substances? So for instance, someone working in a hospital in a COVID wing would likely be at greater risk. And last, was there an opportunity for transmission of COVID-19 in the workplace through a compatible route of transmission? So since transmission through food has not generally been accepted as a means by which COVID spreads, it's possible that the WSIB might not consider this to be a compatible route of transmission, though again, every claim will turn on its facts. And then when looking for confirmation of the diagnosis, the WSIB may look at whether the incubation period, so the time between the date of exposure and the onset of illness, is clinically compatible with COVID-19 infections that have been established to exist in the workplace. So for example, if you have a colleague who was ill with COVID several months ago and then recovered, that may not be clinically compatible if you just developed a COVID-19 illness. And then the second point that they will look at is whether a medical diagnosis has been confirmed. And if not, they will look to whether the worker's symptoms are clinically compatible with the symptoms produced by COVID-19 and whether that's supported by an assessment from a registered health professional. So even if you weren't able to get a COVID-19 test, if you had symptoms that are compatible with COVID-19 and you have an opinion from a doctor supporting that, your claim could still be accepted. And then there's additional limits on what kind of cases can be accepted. So asymptomatic workers are not eligible for benefits, even if they are quarantined or sent home on a precautionary basis. However, if an asymptomatic worker does end up developing symptoms while in quarantine, they may be eligible for benefits then. Okay, next slide, please. Okay, so the WSIB has released some data regarding COVID-19 claims in Ontario. Given that there's been about 548,000 COVID cases in Ontario, there's been relatively few WSIB claims, as you can see here. So there's been around 26,000 cases that were allowed, about 2,000 that were denied. It's still some that are pending. And if we can go to the next slide, please. They've also released a breakdown based on different industries. So if you see here, as you see here, nursing and residential care facilities have the most claims, and then hospitals are closely followed. And as you can see, those numbers are still quite low, lower than we would generally expect. Next slide, please. So this data is a bit concerning. A large number of COVID-19 outbreaks in Ontario can be attributed to workplaces. According to the Institute of Work and Health, approximately 1 in 20 working age adults were infected with COVID-19 in their workplace. So there's concern among unions and workers advocates that workers are not aware of their rights or are afraid to report infections to the WSIB. It's also possible that employers are intentionally not reporting or are not aware of their obligations either. So employers do have an obligation to report illnesses or injuries to the WSIB. And in this case, the WSIB claims to have reached out to employers throughout the pandemic to remind them of this obligation. So I guess one example of this would be the Amazon facilities. Workers are supposed to file exposure incident reports when they suspect that they have been near someone who's been infected with COVID-19. And this report provides the WSIB with data on how many workers have been exposed to the virus and may be seeking compensation if they end up being infected. So despite 600 Amazon workers testing positive at a single location in Brampton, and at least 300 more tested positive at other Amazon facilities in Ontario, there have not been any exposure incident reports, and there were fewer than 5 claims allowed as of April 12th, 2021. So what this comes down to then is workers infected as a result of their workplace may end up on other means of compensation despite having an illness that developed in their workplace. So the key takeaway is that more has to be done to inform workers of their rights and inform employers of their obligations. And I'll turn it back to Jen now.
Thank you, Rita. I'm going to change into talking about changes to paid sick leave. And this primarily affects that second group of workers that I was talking about earlier, who are people who have been required to continue attending work through the pandemic. And what Rita just kind of highlighted is that there's a low number of people who've recorded actually being exposed to COVID-19 in their workplace, and much less than we would expect. But it does appear that there have been outbreaks at workplaces. And so it appears that there probably are people out there who are not getting benefits to which they're entitled. One of the issues, I think, with that is that WSIB, CERB, and EI are all benefits that employees can access, but you actually need to apply in order to access them. So when we're talking about paid sick leave, this is typically a benefit that is employer paid sick leave. So rather than having to apply for it, it's the kind of benefit where if you wake up in the morning and you realize that you're sick and you shouldn't be going to work, all you need to do is call your employer, let them know that you're going to be sick, and you know that you will be paid for that day. So this is something that has been a huge issue for workers' rights advocates during the pandemic, as there's a lot of people who are feeling unwell and financially may not be in a position where they can forego a day's wages in order to stay at home, with which might be COVID, but may just be a cold. So a little bit of a background into paid sick days. So first, in 2017, the Wynne government actually introduced 2 paid sick days under the Employment Standards Act. In 2018, when the Ford government came into power, they eliminated those paid sick days. Now, with the onset of COVID-19, there's been a real push for implementing those sick days. And just to give you a sense, in 2016, it was determined that 58% of workers in Canada do not have access to paid sick days. Now, for workers earning less than $24,000, that number actually increases to 75%. So this is a really, really big issue for low wage workers. And those are the workers that are primarily the ones who are in jobs where they're required to actually go to work. We're talking factory workers, Amazon employees, grocery workers, people like that. So in April 2021, the Ontario government actually introduced the Ontario COVID-19 Worker Income Benefit. So this is 3 paid EDEL days, up to $200 a day. It's available from April 19th to September 25th, 2021. So there's a deadline on it. And it's for employers who are providing this benefit, they can actually apply for reimbursement through WSIB. And one final thing on this is these 3 days are not on top of existing sick days. So if you're somebody who already has paid sick days as part of your contract, these are not additional days because you already have them. So this has been a huge win for workers' advocates. And the question is, what's the future for paid sick days? So as you can see, there's already a deadline for these set to expire. And in the past, this government has been very reluctant to add paid sick days to the Employment Standards Act, something that the employer would have to pay for. But workers' advocates have got their foot in the door, and it may be that these sick days last beyond the pandemic. And I think that would be something that would be really, really positive. The next slide, changes to health and safety. So obligations with respect to health and safety come from the Occupational Health and Safety Act. And there is a section there that sets out that an employer shall ensure that they take every precaution reasonable in the circumstances for the protection of the worker. So this is a pretty robust language. The question here is, what is reasonable in the circumstances? And during COVID, there's been a lot of looking to the Ministry of Health, public health guidelines, the rules under the Reopening Ontario, a flexible response to COVID-19, in terms of trying to figure out, okay, well, what precautions do employers need to take in these circumstances? And it's been something really interesting because, as people know, our understanding of COVID-19 has changed a lot since it was first discovered in January, and our understanding of it is different, and the protections that you want to take against it have changed. So in the beginning, there was a real focus on surfaces. We've since sort of moved away from that to have a greater focus on like air quality. What's reasonable in the circumstances is also going to depend on the workplace. So for example, in healthcare, there's been a big emphasis on personal protective equipment, N95 masks, Whereas in schools, there's been a greater focus on ventilation. In transit services, there's been a bigger focus on like protection barriers between the workers and the public. So in addition to section 25H, there's also another section in the OSHA, which sets out that a worker can refuse work that they believe to be unsafe. So that's something that's always been there, but has been something that a lot more workers have employed during the course of the pandemic to do what we call a work refusal. And there's a process for investigating that and referring to the Ministry of Labor. I won't go into that now, but it is a process that exists and got used a lot more during COVID. I'm going to move to the next slide, which is one of our questions for the recovery. So can an employer require the COVID-19 vaccine? So this is a very popular question, and there's lots of labor and employment law firms who are blogging about that. So if you have more questions about that, I welcome you to check that out. This is the kind of question that lawyers love because it allows us to give our favorite answer, which is it's going to depend. And so I've listed on the slide some of the factors that will weigh into that consideration. And then I'm going to look actually specifically at what we can learn from previous employer policies related to vaccination in a unionized context. And then I'm going to talk a little bit about some of the privacy concerns around the vaccine. So first, in terms of factors to consider, is this a workplace that already requires vaccination? So it's notable that both the Long-Term Care Homes Act and the Child Care and Early Years Act have policies which require employees to be immunized in accordance with their local public health guidelines. So notably, these are workplaces that are focused on caring for the elderly and for young people who are traditionally seen as being the most vulnerable to communicable diseases. So it's very possible that COVID-19 could be added to these lists and workers in those industries will be required to vaccinate. Another question is, what is the nature of the work that is being performed? And what is the work environment? So is this a unionized or a non-unionized environment? I'm going to tackle the unionized question first. So the reason that this matters is for unionized employees cannot be terminated without just cause, which means that to terminate a unionized employee, they must have done something bad. And this is unlike non-unionized employees who, as I said previously, can be terminated for any reason, so long as that reason is not discriminatory or because they were exercising their rights under employment-related statutes. So that means that as long as an employer provides notice of termination, an employer of a non-unionized worker does not need a good reason for termination. So should they choose to end the employment of someone who chose not to vaccinate? Now, an employer with a union actually needs to demonstrate that terminating for lack of a vaccination is a good reason or a reasonable policy. Now, nothing I've said so far takes away from the fact that under no circumstances can an employer enact a policy or refuse to hire someone if it would violate the Human Rights Code. So if the non-unionized employee had a reason for not vaccinating that related to a prohibited ground of discrimination, such as disability or creed, the employer would not be entitled to terminate their employment without demonstrating that to keep them employed would constitute an undue hardship to the employer. Now, this is going to require them to demonstrate that vaccinating is a bona fide occupational requirement of that job, and that no other measures would be possible, such as possible to keep them employed, such as masking or working from home or having that employee engage in regular testing. So it's important to know too that in assessing undue hardship, the health and safety of other workers also needs to be considered. So in kind of figuring out whether or not this is a vaccination is a bona fide occupational requirement, it's really going to depend on the nature of the work that's being performed. So vaccinations in a hospital where you're working with immunocompromised people, or vaccinations in a long-term care facility or in a child care facility where you're working with vulnerable populations may be more necessary and important to the work than for a sanitation worker who's working outside and not directly interacting with the public. Now, I want to switch gears a little bit and turn to what previous litigation around vaccinations can tell us about how this question might be viewed in a unionized context. So a number of years ago, there was a series of policy grievances that are called the vaccinate or mask policy grievances, which involved employer policies that required employees to receive the flu vaccine or be required to wear a mask for the duration of the flu season, so from November until April. Now, workers who were sick and exhibiting symptoms were already required to stay at home. So these policies were really targeted at the asymptomatic transmission of the flu. So the test for whether or not an employer rule is reasonable comes from a case called KVP. I'm not going to bring you through the whole test, but suffice to say, one of the branches is that the rule must not be unreasonable. And in terms of weighing whether or not a rule is unreasonable, we can turn to Irving paper, which sets out that in determining whether an employer rule is reasonable, it's going to require a balance between the employer's objective and the privacy and the dignity of the employee. So the arbitrators examining the vaccinate or mask grievances turned their mind to that question. They recognized that requiring workers to mask for a 12-hour shift from November until April was a really big ask. So they wanted to see that there was a significant benefit to the employer in these circumstances. And in order to demonstrate that, a lot of expert evidence as to the efficacy of the vaccine and as well as masking was led in order to demonstrate the importance of this policy. Now, the rule was actually found to be unreasonable by both arbitrator Hayes in Sioux Hospitals, in addition, and as well by arbitrator Kaplan in the St. Michael's. Now, they both found that the efficacy of the flu vaccine was no more than 60%. So even where a worker was vaccinated, the worker could still get the flu. And there was very scant evidence of asymptomatic transmission of the virus. So those were significant factual findings. And there's many of us who wonder if you were to use the same reasoning with the different facts of COVID, whether or not these arbitrators would have arrived at a different analysis. So if we reran this, and the outcome very well might have been different. So for example, we know that the COVID vaccines are much more effective than 60%. 2, we know that COVID is far more deadly and has longer range consequences than the flu. And 3, unlike the flu, there is a serious problem of asymptomatic transmission. So there's reason to think that if these same arbitrators were considering a similar policy under the COVID pandemic, that their result may be different. The last thing I'm going to touch on briefly here are privacy concerns around the vaccine. So it's generally recognized that there's an expectation that an employer is not entitled to information about your health unless they have a good reason. These are recognized as being private decisions to an individual. So where an employer is asking for this information, they need to have a good reason, which would be very likely developing policies and processes to ensure that workers are safe in the workplace. So if that's the reason that the employer is asking, they may be entitled to the information. Now, once they get the information related to one's vaccination status, they need to keep that information private. So they need to have policies in place to ensure that it's not going to go anywhere else, and it's only going to be used for the limited purpose that they've requested the information for. Moving on to the next slide is another question for the recovery, and that is working from home. So for many people, in that kind of third category, there's a lot of people, mostly professionals, who've remained employed and have just simply moved their work location from their physical workplace to their home. Now that many people have been working at home for 15 months, many of them are asking whether or not this is something they can continue doing after the pandemic, even if the employer wants to resume employing them in the workplace. So one thing to think about here is there's no absolute right to work from home. But as with anything, the parties can agree that an employee can work from home. So you need to work out some of the details, for instance, your computer, your internet, privacy things around documents, things like that. But if an employer wants you to return to work and attend the premises, they can require you to do that. So as with anything though, if an individual has a human rights concern or a code-related reason for working from home, the employer will have to take that into consideration. So for example, if there's an individual who's immunocompromised and at greater risk of contracting COVID-19, should they attend the workplace, an employer will have to consider whether or not they should be able to work from home. So that's something to keep in mind. Working from home also has a number of different kind of privacy considerations, because an employer typically has a right to know that you're working when you're at work. And that's how they, make sure that's happening when you're at work is going to be different than if you're at home. So I think we're going to see more kind of monitoring or surveillance of work. And that's a complicated question when you're actually working from home. So the monitoring that one can do at work is different than the monitoring that one can do at home. And so there's some issues around privacy and that may come up with working from home that need to be kind of considered and addressed. Another thing just to consider is where you're working remotely or working from home and you actually live outside Ontario, there could be an issue of jurisdiction. So which province or country for that matter actually governs the employment relationship. So that's something that kind of needs to be considered and thought about. The impact of work from home on WSIB, that's going to be a topic that Rita is going to address in the next slide. And then the last issue that I'm going to address is your right to work at work. So for many people who've been working from home, they may not want to continue working from home. But as employers are expected to let go of commercial leases, there may be some employers who want their employees to continue working from home. So where you do not want to consider working from home, but your employer does, there may be an argument that you have been constructively dismissed by virtue of a substantial change to your employment contract, and that you're entitled to consider yourself dismissed and be paid your reasonable notice entitlements. So if that is the case, the employee needs to consider whether or not they want to continue working from home or return to work when they're recalled, and they need to make a decision, because if they continue working from home after they're kind of recalled to work, they may have foregone their opportunity to object to it. So something to keep in mind. And then I'm going to turn it over to Rita, who's going to talk about the right to work from home and WSIB.
Sorry, on mute again. If your employer has WSIB coverage and you're now working from home, you may still be covered if you're injured in the course of employment. So this analysis will look at 3 factors: time, place, and activity. So what's considered to be in the course of employment is very fact specific. So for those of us who have been fortunate enough to be working from home, we all know that the pandemic has led to the blurring of work and home life, and to some extent, it has also blurred the lines of what can be considered in the course of employment. Okay, next slide, please. So time. So if a worker has fixed working hours, an injury generally will have occurred in the course of employment if it occurred during those hours or during a reasonable period before starting or after finishing work. And for workers who don't have fixed working hours, or if the accident occurred outside of workers' fixed working hours, the criteria of place and activity are applied to determine whether the personal injury occurred in the course of employment. So it's possible that a reasonable period before starting or after finishing work may be looked at differently by the WSIB for workers who are working remotely versus those who are at their workplace. There may be more potential hazards that one encounters leaving a workplace versus walking from their desk to their couch at home, for instance. Next slide, please. Next criteria is place. So if a worker has a fixed workplace, an injury occurring on the premises of that workplace generally will have occurred in the course of employment. and a personal injury occurring off those premises will not have occurred in the course of employment. Individuals with a fixed workplace who are injured while absent from the workplace but doing work for their employer, or individuals who are normally expected to work away from a fixed workplace, may still be covered if the accident occurred in a place where an individual might reasonably have been expected to be while engaged in a work-related activity. So for many people, the pandemic has caused a shift in what is considered the premises of their workplace. So if you're injured while working from home and you're reasonably expected to be at your home, then you may still be covered. If you've decided to work from your best friend's house for the day, the WSIB may be more skeptical of whether or not this criterion was met. Okay, and next slide, please. So for activity, if an injury occurs while a worker was engaged in the performance of a work-related duty or an activity reasonably incidental to or related to the employment, the accident will have occurred generally in the course of employment. But if a worker was engaged in activity to satisfy a personal need, then they may have been engaged in activity that was incidental to employment. So similarly, engaging in a brief interlude of personal activity does not always mean that the worker was not in the course of employment. So in determining whether a personal activity occurred in the course of employment, the decision maker would look at factors such as the duration of the activity, the nature of the activity, and the extent to which it deviated from the worker's regular employment activities. So for instance, you take a brief break from work to cook your lunch and end up sustaining some serious burns. What the WSIB will ask before looking at entitlement is how far was this act removed from, how far removed from your work was this act? The decision maker will examine the personal activity at the time of the accident to determine whether it was of such a personal nature that it should not be considered work-related. Proving an accident or injury occurred may also be more difficult in a work-from-home environment. So if you're lucky enough to be working uninterrupted, you may not have the benefit of any witnesses. So ultimately, it is an incredibly fact-dependent analysis, but if a worker with fixed working hours and a fixed workplace suffers an injury at the workplace during working hours, the accident generally will have occurred in the course of employment, unless at the time of the accident, the worker was engaged in a personal activity that was not incidental to the worker's employment. Okay, and that's it for this section.
Okay, so before we wrap up, we just wanted to leave you with some final thoughts. In terms of where we see the recovery going, I think we're likely to see a lot more remote work among those companies who can divest themselves of real estate holdings, and for employees who can work from home, and for something that it's feasible. I think we're going to see also increasing concerns over privacy. Because as more people work from home, there's increasing technologies in order to manage and surveil in terms of ensuring that workers are working from home. So that's going to bring to the forefront a lot of issues around our access to privacy in our own homes. And even as it relates to the COVID-19 vaccine, our right to privacy around our medical information. The last piece is sort of an increasing inequality. So while we're all in this together, it's very clear that we've experienced the pandemic very differently. And how you experience the pandemically was linked to your class, your gender, and whether or not you're a newcomer to Canada. So those two first categories of workers, the people who found themselves laid off, and for people who found themselves still attending work during the pandemic, low-wage workers are overrepresented in those groups of employees, and low-wage workers are more likely to be women, racialized minorities, and newcomers to Canada, mostly people without post-secondary education. So those workers either had less money or experienced a greater risk of contracting COVID-19 than for those of us who are professionals who are able to work from home. So not surprisingly, we saw low-income neighborhoods that had the highest incidence of COVID-19. And we would say that, you know what, we can do better and we need to do better in the future should these circumstances arise again, and generally speaking, in terms of protecting our health as workers in Ontario. So with that final thoughts, that concludes our presentation. We hope that you have enjoyed it, and if there's any questions, we could take them now.